Mr. Chairman, Senator Blake, members of the committee and staff, my name is Steve Goldfield. I want to thank you very much for taking the time to inquire into what went wrong in connection with the Harrisburg Incinerator financings. I'd also be remiss if I didn't thank the Harrisburg Authority, who showed the leadership and took a leadership role in making sure that the forensic investigation took place and that as many facts as we could gather got out into the public domain. I'm here today on my own behalf. I'm not here on behalf of the Office of the Receiver or the Harrisburg Authority, and I just wanted to make that clear. I'm here to share the information that I'm aware of based upon the information that we received and interviews that took place that I was present at. I wanted to remind the committee that there were 3 firms that participated in the forensic investigation. My firm was but one of them, and my focus was on bonds, swaps, and municipal finance. My background is as a bond counsel, underwriters counsel, and now I'm a financial advisor for municipal finance. So as such, there's certain aspects of the audit that are outside my area of expertise and that I didn't participate in the research of or writing about.
Good morning, Senators, and thank you for the opportunity to make a brief opening statement on behalf of the Harrisburg Authority. On behalf of our board chairman, Mark Karowski, and our members, Westburn Major and William Cluck, I would like to thank you for this opportunity. The board of the Harrisburg Authority unanimously voted to pursue the forensic audit, which brings us here today. They did so inheriting a resource recovery facility mired in debt and having a critical decision to make with regards to a retrofit, knowing that if the retrofit was completed and we still had a full functioning incinerator, it would not generate income sufficient to pay its debt. For the board, that raised a serious question, and they needed an answer to that. How did it get that way? And as a result of that, they commissioned this forensic audit. They knew they couldn't get answers without the assistance of seasoned and highly qualified professionals. They interviewed multiple candidates, and they put together a superb team of professionals, which included Doug Schleicher, Glenn Weiner, and of the law firm of Claire Harrison, Harvey and Brandsburg, special legal counsel for us, Dave Duffus and James O'Brien of Parente Beard, the forensic accounting firm, and also Steve Goldfield, who is with us here today from Public Resource Advisory Group, who served, as he said, as our expert in municipal finance. On behalf of the board, I wanted to take this opportunity to make clear that even though we intended to waive attorney-client privilege with respect to the report, the discussion surrounding that report with professionals and with the board, we consider still to be attorney-client privilege and confidential matters. They wanted the process to be open and transparent, and they wanted everyone to have a full picture of what went wrong in Harrisburg and who created the mess here. However, they still wanted to maintain the privilege with counsel that is attendant to what may have to occur in the future. Further, the board wanted you to know the scope of this audit was limited by our resources and our inability to compel production of documents and to depose key witnesses. The forensic audit will serve as a starting point, we hope, for further investigation, and that's why we applaud this committee for taking up this initiative. Finally, I'll just remind you that Mr. Goldfield, as he said, is testifying as an individual before the committee, and his expertise is in the financial area with bonds and swaps. Neither he nor any other member of our team was asked to draw any legal conclusions. They were not asked to do anything other than to uncover and analyze the history of the transactions that led to this fiscal crisis. Whether laws were broken, by whom, and whether laws need to be changed are matters for others to decide. Once again, I thank you for this inquiry. The board's hope has always been that if responsibility lies with individuals or institutions, that they will be held accountable. And if current laws are inadequate to protect municipalities of this kind or others from this type of malfeasance, that those laws are changed. Thank you.
There are many, many extraordinary trails that could be followed in this saga, and as we both have said, the forensic investigation is really just a starting point. It's a roadmap. It identifies issues and concerns. I thought that a lot of those other trails are very important and could lead to very important issues that the committee may wish to pursue in the future. I can tell you from working on this for many, many months that some of those trails lead down rabbit holes. And so what I wanted to do is, with the precious time that I have, is to really stay focused on specific issues that I was involved in, that I have experience in, and that I thought were germane for this committee to focus on this morning. 3 issues. Why didn't the borrowing limits in the law prevent the city from taking on so much debt? I thought that was probably the most important thing I could talk about. Second issue, there's all this debt, there's an incinerator that works fine, but the incinerator can never, ever carry the debt service. So what happened to all the money that was borrowed on behalf of, or ostensibly as in connection with, the incinerator? And third, if I have time, I'm going to briefly touch on swaps and the swap portion of the audit. That alone, I know there have been committees that have looked at whether Act 23 should be repealed. I have a fair amount of experience in the area, but I'm afraid that if we have to spend too much time on swaps, we're not going to be able to spend as much time as you probably would like on debt limits and other things within your purview. And so, time permitting, I'll touch on that. If there are questions about swaps, please feel free to ask them. Okay, so why didn't the borrowing limits prevent the city from taking on so much debt? That's a very essential question to make inquiry about. The city of Harrisburg has approximately 50,000 people, annual budget of $56 million or so per year. It's now being asked to repay, and of course it goes up every week, approximately $340 million. This is about 6 times its annual budget. It could never hope to repay that. Okay. So how did it happen? Where did the money go? What laws were in place to prevent this from happening? I think it would be helpful first to just touch on the basic framework of what the law says that's in place. I know that the Department of Community and Economic Development will be here and will give you as much as you need about the Debt Act, but there are 3 key provisions in the Debt Act that are essential to follow the facts in this inquiry. For the most part, the Debt Act is deemed to be procedural. It's the process by which local governments incur debt. It's when do you have to advertise? When do you have to hold a hearing? What does your resolution or ordinance have to say? What needs to be done before you apply for approval? When does that have to go in? How much time is there for appeal? So for the most part, it's procedural. And a lot of people will say it's all procedural, but it's not. There are 2 key areas that are substantive and designed to prevent the incurrence of debt beyond the tax base. Okay? And that's what I want to focus in on now. So the financings that we're talking about today ostensibly related to the incinerator. The city did not actually borrow the debt. Okay, they're not the borrower. You'll see official statements that say the Harrisburg Authority. The Harrisburg Authority actually borrowed the money. But the city guaranteed the debt of the Harrisburg Authority. And a guarantee under Pennsylvania law is the incurrence of debt. Okay, so that's the first important thing to realize when you're looking at all these documents. There's the Harrisburg Authority, they own the incinerator, they've got the debt. Why is Harrisburg on the hook? Well, they guaranteed it. So whatever the incinerator can't generate through revenue production, the city has to pay. A guarantee is a type of debt under the Debt Act, and there are limits, specific limits as to how much the city is permitted to guarantee unless the debt is self-liquidating. So this is the jumping off point for the discussion. What is self-liquidating? Why is self-liquidating debt not counted towards the debt limit? Is it, being used properly? Is it appropriate the way that it's being used in the Commonwealth in this instance, et cetera? So what's the definition of self-liquidating debt? It's a term of art. So if somebody says to me, is it self-liquidating debt? I can't answer that because it's defined. It's decided in the first instance by the public officials who are elected who decide, can I borrow this? Should I borrow this much? Do I have too much debt? It's decided by financial advisors, bond counsel, underwriters, staff. Is this going to pay for itself? So once that's decided, if proceedings are submitted to DCED, you'll hear about what they have to say about whether it is or isn't self-liquidating debt. Really, if it went through all of those people, and including DCED, and we decided we don't think that looks like it's self-liquidating debt, and DCED said they thought it did, and all the law firms said they thought it did, and all the elected officials say they thought it did, it would be up to a court to decide. So I'm not going to be able to answer was this self-liquidating debt or not, but it's critical to understand what self-liquidating debt is, and then I'm going to walk through each of the financings briefly and walk it through the definition so that we can see, how this happened. So the definition of self-liquidating debt is debt payable solely from rents, rates, and charges, to the ultimate users, okay? So for example, if a sewer authority has a facility that treats sewage and collects and then treats, it sets its rates and charges at an amount that's sufficient to pay all of its operating expenses, its regular improvements, and its debt service. If that sewer authority sets its rates properly, it will have enough money to pay all of those things, and there will be no need to call on the guarantee of the city. If an incinerator that can set tipping fees and sell electricity for a sufficient amount to pay for all of its operating expenses, all of its improvements, and all of its debt service, is guaranteed, then that incinerator can, with proceedings filed at DCED, apply for approval of self-liquidating debt status. And that's what happened here. The reason that it doesn't count towards the debt limit of the guarantor, in this case the city, is that the guarantor is never expected to make payment under its guarantee. And thus it's not required to include that guaranteed debt, which has been approved as self-liquidating towards its borrowing limit. So one thing that, from a policy perspective, that's interesting about these two examples is that a utility, for the most part, doesn't have competition. And if it falls short one year, it may need to call on the guarantee, but it'll raise rates the next year. A facility like this has competition from landfills, maybe other incinerators, and electricity prices are volatile. So there's no way to know what you're going to be able to sell electricity at for 30 years. And in the case of this incinerator, the overwhelming majority of the revenues were from tipping fees, charges that garbage trucks are charged to dump municipal waste, and electricity. And there was no control over those because there was competition and there's market electricity prices. So long as the debt remains self-liquidating, the city can report, and this is in the audit, and you'll see we kind of coined a phrase because we had to say it so many times that we thought it would be easier to follow. The city can report in a certificate under Section 8110B of the Debt Act that no decrease in the amounts to be excluded is required by any change of circumstances. We call that a clean 8110B certificate. So the utility that I talked about sets rates and charges, does a good job, pays for everything, including its debt service, every year for 10 years. When the city goes to borrow the next time, it can submit to DCED a clean 8110B certificate. It can say, never called on the guarantee, revenues are sufficient from user fees to pay for all the debt. I don't ever expect to have to pay on my guarantee, so I'm not going to decrease the amount of self-liquidating debt that I told you about before. Just as an aside, the legislative history of the Debt Act, 73 maybe, originally required an annual certification that all debt that was deemed self-liquidating is still deemed self-liquidating. So there was going to be an annual requirement that it be certified to the department to keep up with, changes in circumstances. That's not what was promulgated into the law. What was promulgated into the law was you're self-liquidating on the books of DCED until the next time you borrow, right? Because you've already borrowed, and if it turns out that the rates and charges aren't enough, you may lose some borrowing capacity, but you can't take the bonds off the market. So the idea is the next time you go to borrow, you must either deliver a clean 8110B certificate, that we know of no circumstances that would result in us having to decrease the amount of debt on the books that's self-liquidating, or you have to tell DCED there have been changes in circumstances that would result in us having to decrease the amount of debt that's self-liquidating. And of course, these are they work in opposite directions. You decrease self-liquidating, okay? Actually, it's not really opposite directions. If you decrease self-liquidating, you decrease your borrowing limit, right? So if you were right up to your limit and you decreased the self-liquidating debt, then you couldn't borrow anymore. And that's the way the law is supposed to work. That if you get to a place where you thought a lot of debt was self-liquidating and you were wrong, that it prohibits you from borrowing any more money until you get more borrowing capacity. Why do you do this? Why does the authority ask for a guarantee by the city? It reduces the borrowing cost. So for a utility, water, sewer, before the Harrisburg crisis, you have a general obligation guarantee, the gold standard in the bond community. If you have a high-rated entity, Dauphin County, and you get a AA GEO guarantee, the credit markets are willing to loan at much lower rates. You get to then pass that along to your users. You get to pass along the decreased expense called debt service to your users. So you either get to decrease your rates, or more likely, you get to reduce the increase in your rates when you build something. So it makes sense to have this construct. And it's used in the city of Harrisburg very well with the parking assets. Most of the parking debt is guaranteed by the city. The parking debt has no trouble paying all of its operations, all of its improvements, and all of its debt service. It's deemed and it's approved as self-liquidating to the city because the city never expects to have to pay on the guarantee. I'm going to pause because now I'm going to jump into a second concept and the last concept before I get into the report and ask if there are any questions.
You want questions now?
Only if you have them. We can wait. I just wanted to take a breath and tell you that I was going to move on to one more concept in the Debt Act.
Okay, we could. You want to wait? Okay, we'll wait.
Okay, thank you. The second area in the Debt Act that I want to frame because when we go into the audit, we're going to walk through, and I'm going to go back to these two concepts. Self-liquidating debt. Is it? Should it have been? You know, the second one is very important, and it's going to be more important as the federal government moves programs to the state without appropriate funding. The state moves programs down to the local governments without complete funding. And the local governments have pressure to not raise taxes, but to provide essential government services. And I have to say, I am an elected official in a very small town in the Commonwealth, and I sit as the chair of the Finance Committee, not surprisingly. I think they say a volunteer is the person that didn't understand the question. I know what this pressure is, and I know that you have to get creative, and I know that you don't want to raise taxes and you don't want to cut services, and it's very challenging. This is going to get worse, and I can see in my profession the pressure in this area. This area is the Debt Act limits a city's ability to borrow on a long-term basis for current operations. We call it working capital. It's more of a business and tax law and Debt Act terminology, but it's really your operations. So if you don't have enough money to pay for your operations this year, you have some choices. You could cut program, you could raise taxes, or you can borrow. If you never address the structural deficit, because you don't want to cut taxes or cut programs sufficiently to run a balanced budget, and you borrow for operating expenses this year, and you do it again next year, and you do it the year after that, it's akin to paying your rent with a credit card and never paying the balance off and continuing to do it. At some point, you're paying exorbitant interest rates, you haven't addressed the problem, and the debt load is beyond your capability. The harm intended to be prevented is like that. It's like the idea of getting into a floating rate mortgage and hoping the rates will stay low and hoping something will turn out. So the Debt Act has a proscription against borrowing long for current operations because it's a recipe for financial disaster. Again, the structural deficit is masked when you do that. So unless it's part of a construction project, working capital cannot be financed on a long-term basis without court approval. That's the hurdle. And there's a whole process in the Debt Act about what you need to show. And it's basically, you're in a crisis, necessity, there's no other way out, you have to do it. And there's not a ton of this. It's called unfunded debt under Pennsylvania law. But there are unfunded debt proceedings, and you'll see more and more. So the exception is if there's a construction project, and this is where it gets very interesting with the incinerator, then you can finance working capital. What the Debt Act says is a reasonable initial, two key words, reasonable initial working capital for the operation of a project may be borrowed, as may interest on money borrowed to finance the project. We call that capitalized interest. When you take out a new mortgage and you throw all your costs into it, you're basically borrowing those costs and spreading it out. It makes sense. So if you have an incinerator, let's take the first day that you decide to build an incinerator, you build it. It's not going to be receiving trucks the first day, and it's not going to be selling electricity the first day. And you're still going to need to hire people, and you're still going to need to test the equipment, and you're still going to need to ramp up operations. And so it's appropriate to have reasonable working capital until you're in operations, maybe call it stabilized operations, we're running now. Same with interest. You don't have the money to pay debt service on day one when it opens because it's just not cash flowing like that. So the Debt Act says you can borrow to pay for principal and interest through the date of completion of construction, and if deemed necessary, 1 more year. Because again, the day you open, during construction, you're not making anything. The day you open, you're not efficient. So if deemed necessary, 1 year thereafter. An extraordinary amount of proceeds of the borrowings that we're talking about today, ostensibly related to the incinerator, but they weren't used for construction. They weren't used for equipping. They weren't used for improvements to this incinerator or anything that would improve the revenues of the incinerator. And that's where we're going to start our inquiry. What were they used for? And if this thing wasn't carrying itself, why was it self-liquidating? So let's turn to the forensic investigation, and I don't know whether everyone has a copy, but to the extent that we have copies, I'm going to call out pages if you want to follow along and put asterisks down, okay? So the incinerator trials and tribulations date back pretty far. We were engaged really to start in 2003, but as we got into it, we realized that it would be very important to look at the purchase of the incinerator by the authority to the city and the course of conduct in the 10-year period before the 2003 issue to provide us with context as to what had happened before that may have informed what the heck's going on now. So I just want to let you know that we're going to start in 1993, and it wasn't part of our original scope. We went back to the authority and to Royce and said, we think this may be important, and they said, we think you're right. And so you'll see less treatment of, but some treatment of 1993 to 2003. So we're going to jump into the forensic audit. On page 19, the resource recovery facility was experiencing operational and regulatory problems at the time the city sold the facility to the authority. Okay, so this wasn't, you know, the crown jewel, here, take it, this is going really well, you don't know how good it's going to be. This was an old facility that had operational problems, regulatory problems, and it was sold to the authority. So I know former Mayor Reed's going to be here, and asking him, why did that sale take place? What were the purposes for selling the incinerator to the authority in 1993 would be an interesting question we don't know the answer to. But in the early 90s as well, the resource recovery facility was experiencing reduced waste flow, so big deal. Big deal is that there's two things that really generate revenue: electricity sales, tipping fees. Waste flows means truck tipping, $50 a ton. That revenue is very important. So there wasn't really a revenue stream that was growing. There was a revenue stream that was declining, regulatory issues that were going to cost a lot of money to address, and the facility wasn't operating that well. It needed to be fixed. It needed work. So first bond issue, we call this an acquisition financing. Let me get to page 26, pardon me for a second as I scroll. The first bond issue was a sale. But it's like a sale to a related entity almost, because the Harrisburg Authority was created by the city, and this is very common, in utilities to create a municipal authority and have them focus on water, sewer, things that general government might need to spend more time on to really do a good job on, and it allows the the government to focus on more of the essential government services. So the sale occurs, and this is really important to understand. The price of this incinerator that now has $340 million of obligations was $26.7 million originally. Okay, it's been retrofitted, so I'm going to talk about the improvements in the retrofit. But this all started in 1993 with a sale for $26.7 million. And on top of that, the authority borrowed an additional $7.5 million to improve the facility. As I said, it wasn't in great shape, it needed some work. So the total cost for the acquisition plus the original improvements was $34 million. At this time, Dauphin County was not sending its waste to the incinerator, and so there were flow issues. Whether that flow could improve or not was anybody's guess. The city guaranteed this debt and filed, we think, because we don't have all of the paperwork, but it appears that they filed for self-liquidating debt status. This incinerator, for I think the exclusion at that date was $28 million of that debt, will be self-liquidating. That is, it will pay for operations and debt service out of charges for tipping fees and electricity. If the next day that wasn't true, the city wouldn't have been under any obligation to do anything about it. The city would only be under an obligation under the Debt Act to do something about that the next time the city borrowed and filed proceedings, and they'd either file a clean 8110B, or they would say that circumstances have changed, and therefore we're unable to file a clean 8110B. Please mark this debt no longer self-liquidating and reduce our borrowing capacity. 1996, 3 years later, the authority borrows, not guaranteed by the city, the authority borrows $3.5 million. Approximately 2.8 of that is for working capital. Okay? So the alarm bell on panel 2 goes off when somebody like me reads this. It's wait a second. 3 years ago it was self-liquidating, you're borrowing for working capital. That means you don't have enough money to pay for your operations and your debt service. Why was the authority allowed to borrow for working capital? Remember, the Debt Act does not regulate municipality authorities. That's the Municipality Authorities Act. The Debt Act regulates local government units, including the city. There was no city guarantee on this borrowing. The city was not required to make a filing on this borrowing, so they were not required to do anything vis-a-vis an 8110B certification. But it's a signal that this facility is not cash flowing. We then go to 1997, 1 year later. The authority, again, not guaranteed by the city, borrows $3 million to refinance the 1996 borrowing that we just talked about. So they borrowed for working capital for a year or so. And then they borrowed for working capital by refinancing their working capital. Very interesting. One thing that could have happened is the city could have actually used its guarantee and said, you don't have enough money to pay for operations and debt service. Authority, you pay for operations, I'll cover debt service under my guarantee. The city, unlikely, because in my experience this is unlikely, guaranteed operations, but clearly guaranteed debt service. So if they didn't guarantee operations, they were under no obligation to file with DCED any change in circumstances or use their guarantee. But they could have seen this as an early warning sign and said, you borrow for your, you take care of your operations, the shortfall's on me, okay? The debt service, that came out of this refinancing is the first of many indications of borrowing, going longer, restructuring, increasing costs, increasing debt on the facility. So this little 1997 borrowing stretched out the term of the original working capital financing. So, you know, you pay your rent, you put it on a credit card for 5 years, and you pay your 1 month's rent off over 5 years. Well, you can do that, it's legal. It's not financially prudent, and it's usually very expensive. And this was very expensive debt for 53 months, so you're just over 4 years, 6% borrowing, because it wasn't on the city's credit. It was just on the authority's credit, and the authority obviously wasn't doing so well. So 97 takes out 96. Guarantee's not hit on yet. 97A occurs. I'm on page 27 now. And 97B as well. 97B was capital additions. So now we have a capital project. So, you know, add to your original purchase price plus the amount of original improvements, we're putting another 7.9 million of capital repairs. So that's good. You know, maybe it'll generate more revenue. That's, a good thing. Small amount of capitalized interest in working capital, $539,000. So we're borrowing Cap-I, as we said, in connection with a construction project. If you were trying to make it more efficient, you can borrow for working capital and Cap-I, and this didn't cause us any concern. What we heard in our interviews was that at this point, the city and the authority were shopping the resource recovery facility. They were either going to sell it. I think they saw the writing on the wall that, you know, the regulatory improvements were going to be expensive. The flow wasn't there. The electricity prices weren't there. It just wasn't working real well. Or they had to expand the revenue base, the transfer station and operations, and start getting waste from New Jersey and other places because this wasn't working. Okay? But to date, we only had one borrowing guaranteed by the city, and then a series of small working capital financings and refinancings of working capital financings, and one more improvement. Okay. 1998. 1998 is an important year because now we really do implicate the guarantee. We roll up the authority debt, the 96s and the 97s, and the 93 into a 98 bond issue. So now that's our, we've rolled the whole thing. We've consolidated our loans, so to speak, in one transaction, $55.8 million, to refinance the 93s and the 97s. But it wasn't to save costs. So when I refinance my mortgage, it's because I was paying 5 and I can get 3.5. I could reduce my costs. That's a really smart refinancing. The other kind of refinancing that is permitted under Pennsylvania law is a restructuring. And there's all different levels of them, but the worst one is called a scoop and toss. You just take what you're owing the next 2 years because you don't think you can afford it, and you chuck it out long, and you pay interest on it for 20 years instead of 2 years. And we in the financial advisory world actually can calculate, the present value cost. This was not a refinancing for debt service savings. It was a legal way to create working capital. If I need $100 to pay my operating expenses and my debt service, and I only have 90, then if I take $10 of the debt service owed that year and the next year and the year after that, and I toss it out long in a new borrowing, then I don't need that $10 anymore. I've created working capital. I've created revenue available to make myself whole for that year. Okay, so various degrees of restructuring, but when we talk about a restructuring, and again, it's permitted under the Debt Act, we talk about not necessarily a refinancing for savings, because the Debt Act has authorization for refinancings for savings, and it has all sorts of procedures for showing that. This is a refinancing to create some breathing room. Another signal that the incinerator was not paying all of its debt service and operating expenses. So question, pausing point. At this point, the city could have, again, paid under its guarantee. It says that the city shall pay an amount sufficient to cure any deficiency. It shall punctually pay from its revenues or funds to the trustee the debt service. So one option is that the city advances the money that the facility was short that year, and if it's running a balanced budget, that's going to be a little bit of a hardship. If it's running a surplus budget or has a big balance, fund balance, maybe they could do that 1 year and then get it fixed for the next year, or redo their budget, increase their budget because they've covenanted under the Debt Act that they are going to budget and appropriate what's necessary for the next year. So if they know that they're $20 short and they're going to expect to be $20 short next year, then they should budget $20 more. That's another way it could have been done. How it was done was a restructuring. Guarantee wasn't hit on. The budget wasn't changed. Importantly, the self-liquidating debt status of this debt was not downgraded. So when you did the 98 deal, you refinanced the 1993 bonds. There's a certificate that would relate to the 93 bonds, but they're not outstanding. I refinanced them. I rolled them up into this consolidation. But in 1998, an exclusion was applied for 100% of this debt. So you see the debt's mounting. A lot of it is used for working capital. Some of it's being used kind of backdoor restructuring to get through a year or two. But the question that we asked is it really in 1998 all self-liquidating? The proceedings were prepared. The pieces of paper that were supposed to be filed were filed, and it was approved. The other thing that happened in 1998 was that some of this money went to replenish the facility's operating reserve fund. The operating reserve fund is there for if you have a blip in operations and you don't have enough money to pay for your operations. They obviously used all the operating reserve fund, so that's not revenues or rents from the users. That's digging into the operating reserve fund. Another alarm bell goes off. You're not funding everything that you need to with user rates. Is it really self-liquidating at this point? 2000. I'm on page 28 for those who are following along in the report. The authority issues an additional amount in 2000 of approximately $25.2 million to restructure. Here we are again, okay? We don't have enough money for operations, we don't have enough money for debt service, or we don't have enough money for both, but we don't have enough money. It's effectively reimbursing itself for prior payment. My recollection is that there may have been an advance funding by the city here, and it paid itself back for that advance funding. So whether it was short and the guarantee was hit, that's still not self-liquidating, or whether it was just borrowing to restructure to ease the expense load, right? Because you could decrease expenses and be self-liquidating. That's fine. If you have 10 employees and you're not able to pay for all your operating expenses and your debt service, and you decrease your expenses, then and you're back in balance, you're still self-liquidating. So you could decrease your expenses, you can increase your revenues. Here's a way to decrease expenses. I'm going to scoop up principal and interest over the next year or two, and I'm going to pay it later. So I've reduced my operating expenses, so now I'm whole. But $25 million. At this time, we're in 2000 now, the facility's clearly not generating revenue sufficient to pay debt service on the 98 bonds and the 2000 notes. There's no question about it. But worse is the EPA is about to shut down or at least derate, meaning the amount of tons that you can take in and burn is going to be significantly reduced because of regulatory problems. So it's going from bad to worse, and we're only in 2000. We haven't even gotten to the starting point of the audit, and this is why I wanted to give some context. A derating agreement with DEP and EPA reducing the volume of waste was the best case scenario at this point in time. The worst case was a complete shutdown, and all of the debt would have been stranded, meaning that somebody would have had to pay for it and there wouldn't have been any revenues. You wouldn't have had any operating expenses, but you wouldn't have had any revenues. This is the first time I want to bring up the disclosure document because a lot of people have asked me about the various levels of law and analysis, and as a former bond lawyer and underwriters counsel, it's not uncommon for, from a timing standpoint and from a law standpoint, to see things slightly characterized slightly differently. But here we go. An official statement is like a prospectus and a corporate offering in municipal bonds. It's supposed to tell the reasonable investor everything they need to know about the investment. Municipalities aren't subject to registration of their offerings, but they are subject to the anti-fraud provision. So if a municipality does not disclose everything that is material for a reasonable investor to make their investment decision, or omit something that would have been material, they could be subject to liability under the anti-fraud provisions of the Securities Act. So it's important. We spend a lot of time making sure that disclosure is good disclosure. And I think this disclosure was good disclosure. It said to the note purchasers of the 2000s that while the transfer station was fully authorized, it would not be able to generate revenue sufficient to pay for operations and debt service on either the 98 bonds or the 2000 notes. So you're telling the people who are going to buy the debt that we're fully operational as best as we can, but we're not going to have enough money to pay the 98 bonds and the 2000 notes. They were also told that under a number of circumstances, the operation of the existing resource recovery facility may be restricted, halted, or terminated. We could have a shutdown. In such case, the debt service on the 2000 notes would have to be paid partially or solely to the extent of payments made by the city under the guarantee agreement. So we're back to self-liquidating still. Should these bonds have had a filing made that said that the other bonds are no longer self-liquidating? Do we reasonably expect that the guarantee will never have to be hit on at this point? Or do we, and it's not an all or nothing thing. You know, there could be enough revenues that you say, well, 50% of this is still self-liquidating, 50% isn't. So it's impossible to say, you know, without being there at the time, what our analysis would have been as to how much was self-liquidating. There was still some revenues. Unless you can't even pay for your operations, if you create $1 above operations for debt service, then you've got, some is self-liquidating, but greatly reduced. Did the city change its budgeting and appropriate for the next year an amount that it expected would be needed again? No, because it restructured, so it threw the bonds out and it didn't need to. And it didn't reduce the amount that was deemed to be self-liquidating. There's another thing that could have been done, and this is second guessing, but I just want to put it all out there that there were options, there were choices, and choices were made. But one of the choices was, we've got some stranded debt. We have $80 million of debt on this facility that we bought for $27 million and put maybe $20 million in. It's not going to cover this. Let's consider some of the debt on this stranded debt, and we'll issue, we the city, general obligation bonds, and we'll amortize that over a period, and we'll say that's stranded, and And as we interviewed people, that was posited in the early 2000s as the way out of this. There were people in the city who said, shut it down. It's an albatross. Shut it down. But the question was, who's going to pay the debt? We've got to pay the debt. Borrow for it. So we got into trouble borrowing. We're going to borrow for this. You know, I have other things I want to do with my GO debt. I have things I need to do for the city. Whatever the answer was, that is one of the options, and that wasn't an option that was pursued. I'm on page 29 now. We're at the 2002 notes. $17 million borrowing, 1.9 of which for capital projects. So we now know what the rest was for, right? We know it's capitalized interest and working capital, because that's the theme here, and that's why we wanted to show some of this. Over $12 million of this borrowing was used for working capital, and $1.1 million was used to pay the current interest on the debt that the facility couldn't pay. Clear indication that the facility was not servicing its existing debt. 8110B certificate, option, clean, reduce the amount of debt that's on the books at DCED that's deemed to be self-liquidating. It was filed clean. City guaranteed the 2002 notes. Let me introduce another player. Used to be known as FSA, a national bond insurer. Went out of business, now known as AGM, Assured Guarantee. FSA insured the 1998 bonds and the 2002 notes. So now we have a city guarantee and an FSA insurance policy. So if anyone out there is saying, well, if you're disclosing all this bad stuff to the markets, who's foolish enough to buy this paper? And the answer is the people who don't look at the underlying operations, who say, well, I'll get paid on a timely basis by FSA. At that time, there were, 5 AAA bond insurers that everyone said, what could go wrong? Well, none of them are left. One is standing, AGM. They're down to a AA minus with negative outlook. And the city could not ever even pay off the amount of debt that we're talking about now, let alone what we're going to get into next. 2003 ABC, a massive restructuring. There's a good picture of what a scoop and toss looks like, because that's what this is, on page 30 of the forensic investigation. You can see this is inside baseball financial advisor stuff, but we love a straight line when we're looking at debt service, or a declining line when we're looking at debt service, because it means there's nothing on the come. We've got level debt service, very conservative. You don't have to rely on rate increases in the future. You don't have to rely on tipping fee increases, electricity price increases, nice and level. That's what it was. On page 30, mine's in color. All of the white is what was prior to issuance of the 2003 ABC refunding bonds, and it was all picked up and tossed out long so that the debt service due on the bonds was reduced significantly, and with an additional purpose, not just the purpose of we don't have enough money to pay our debt service and we don't want to pay under the guarantee and we don't want to ruin our debt limit, but we're now at a place where the 2003 D, E, and F retrofit bonds are being contemplated, and the masterminds behind the retrofit say that's going to cost a lot of money and we don't have enough money to pay for our existing debt service. How are we going to even pay the interest on that debt service? And the answer was, we'll make a lot of room. How will you make a lot of room? We're going to take a lot of your debt and we're going to move it out long. Did anyone say how much that would cost? We're asked that all the time. We did an estimate We didn't find anything in writing that said, gee, that's a little risky, that's a little expensive, how much is it going to cost? It may have happened, we didn't get all the paperwork. But our estimate, 9 years later, trying to retroactively figure this out, was it cost about 10 million of additional debt. So there's lots of pieces here that are going to add up to the answer to the question, how is there all this debt on this facility? The facility seems fine, but where did all this money go? Okay, so here's $10 million of debt that was added to the burden to allow for the 2003 D, E, and F retrofit.
Because we'll all have questions, and we could probably be here till midnight tonight with, I could probably be here till midnight, and I'm sure he has and Mike has as well. So maybe if we ask one or two each, and then we'll kind of keep it in check. How about Senator Blake? Do you want to start?
Thank you. I'm deeply grateful for the methodical and very professional and thorough work that you and the team did on this audit. So let me just start there. I guess there's a couple of things that I'm trying to wrap my head around on the basis of everything that you've just said. My first question was going to be, you've raised a lot of red flags in this forensic audit. Could you clarify them? Well, you've just clarified a whole pile of them for me. I'm trying to have an understanding over the statutory basis in Laguda regarding self-liquidating debt. That is supposed to, there is supposed to be some meaningful analysis of a change in status. You've consistently said that it was clear, it was evident that they were not meeting operations, they were not meeting debt service obligations, and yet there is this prolonged assessment that this is self-liquidating. I'm trying to understand where that disconnect is, if you can help me.
I'll try. The self-liquidating debt component of the filing with DCED is considered by some as a separate set of proceedings. We would call them the self-liquidating debt proceedings. And it's a package, that's spelled out in the Debt Act of what needs to be there. And one of the things that needs to be there is a professional with experience has to do a report that demonstrates that the revenues will be sufficient to pay operating expenses and the debt service. And if that report is not in the filing, the DCED will kick it out and say, I can't give you an exclusion. So number one, there needs to be the folks who are the actual movers of the project need to tell somebody, to apply for self-liquidating debt status. Number two, the professionals need to advise the issuer as to, whether this would qualify or not qualify. That's bond counsel, that's financial advisors, that's solicitors. Number three, they have to go out and get a professional to look at the operating side, and then usually the underwriter does the bond debt service. They just run a bond debt service and say, well, here's how much it's going to cost. Now you tell me if you can cover operations in this amount. And they put that package together, and as long as it satisfies the, the definitions in the Debt Act, DCD approves it. They don't have the staffing to do an independent analysis, and they don't think that it's appropriate for them to, go out to a facility and do diligence or to, research authority bond issues and what they were for, because they've never seen that. They basically call it on the papers.
Understood. And you've answered my question about the issue of capacity and an independent third-party objective underwriting. The dependence is on the professional consultants engaged by the parties in question to make a representation to the department.
I would say that's the gatekeeper of first resort.
I understand. I don't want to take up too much time in deference to the chairman, but the other thing that seems to jump off the page in this audit consistently, and more particularly relating to the last two elements of your commentary leading up to my questions, is the issue of a complete disregard for the cash flow situation of this facility and a complete reliance upon the guarantees. Is it fair? And I guess I'm trying to find out where there is either a statutory or regulatory protection against what I'm hearing here. But it seems to me, and you, to your point, you said, who's buying this paper? Who's buying this paper are the people who don't care about the cash flows. They care about the guarantees. And that's part of the problem here, and I'm wondering whether or not, in your experience, you can advise us in this committee on how we can omit that danger for our taxpayers.
Yeah, I think that this would be something that I'd want you to hear from a lot of professionals, and obviously this is my opinion because you've asked for it. I think that one distinction could be that a utility where you have control over the rate setting, or some notion that you've got a captive user base and you can always raise rates even if there's a one-year blip that you did on the guarantee, makes sense and can reduce costs like taxes, but of rates. One distinction I tried to bring out before is that there's a lot of stuff going on. It's a little bit on the proprietary side, right? It's a great project, by the way, turning trash into electricity. But back then, they didn't have what we would call flow control, where all of, and we're going to get to that because we have it now, but where all of the county had to, by ordinance, deliver its trash. So you had competition amongst waste haulers, and if your price wasn't good, they would go dump it in a landfill. And we're going to get to that too, because that's what was happening. Landfill costs versus incinerator costs. You know, a trash hauler is going to get paid by the municipality a contract price, and they're going to take it to the cheapest place because that's where they get the most profit. So there's competition out there that government maybe, you know, isn't in a good enough position to, you know, assess. There's more risk to it anyway. And then electricity prices are, you know, very volatile. So, you know, what DCED will get is they'll get this thing that says for the next 30 years, we're assuming electricity prices will be 5.5 cents per kilowatt hour. Well, what are they supposed to do with that? Are they supposed to, you know, get an independent consultant in and a forecast and try to figure out whether that's reasonable or not? So there's no reasonable test or you know, statutory provision. I don't know if there could be. I don't think the government wants to, you know, build up to that. So what that does is it backs me into when you've got, you know, that much volatility on the revenue side that you don't have control. Maybe that's not a good project to have a guarantee of.
I appreciate that response, and I'm going to hold the rest of my questions and defer back to the chairman, but I just want to summarize what you've just said that I think is important for us to consider, which would be the attributes of the facility and the economics and the financial performance and the reliability of the financial performance of a facility of a particular set of attributes. Your contrast being a utility versus this resource recovery facility and the revenue streams upon which it relies. I think that's an important consideration for the committee, and thank you.
I have one question. I may be jumping ahead a little bit, but I'm looking at page 124, the footnote 447, IBID section 6.01B. There seems to be a lot of these accounts being set up. I'll name a few and I'll be quick. The retrofit working capital account, the retrofit capitalized interest account, the retrofit capitalized debt service account, the retrofit construction account, the surplus fund, the retrofit debt service account, the retrofit sinking fund account, and the retrofit debt service reserve account. How do you keep track of all these accounts, and is this normal? Is this, what is this?
First of all, I want to thank you for reading the footnotes because it's our favorite part of the report. We think that most of the juice is in the footnotes, and not everybody admits to us in public that they read the footnotes. Second, it is a byproduct of having done this kind of work for about 15 years. That's why I was brought in. It would have taken, you know, forensic auditors who don't do this a lot longer than it took me, so it's pretty efficient. Third, and probably most importantly, is that as we get to 2003, you're going to see convoluted structures and strained interpretations that create more and more levels of subordination and accounts, and it's one of those things where when I see it, I know that there were some tricky legal calls, that there were constructs created in legal documents to get around concerns or to try to build a structure that fit into something that wasn't necessarily usual and typical.
Then how much did they push the envelope then? Is that hard to say?
What I'd request is that we get through
Okay.
a little bit more.
I'm sorry.
And that we can talk about where, and then in terms of quantifying how much, I'm going to leave that to everyone else.
Thank you, Sharon.
How about, a thought that came to me when you were talking about the benefits of getting guarantees from the city and the county, or you were talking about the city at this point. I could not find, and maybe it was there and I just missed it, where there were quotations done without having the city guarantee. And the reason I ask about that is, for the overall cost, if the rate was much cheaper having the guarantee, I understand that, but that also forced them to borrow millions of additional dollars. So was the overall cost still less, even because it was a cheaper rate? Or was the authority obligated, since they were obligated for millions of additional dollars, was this still, was it a worse deal?
And I'm not pandering, that's an excellent question, and I'm glad you asked it. That is exactly what I would have wanted my client to ask, and what I would have told my client they should expect. Guaranteed, how much will it cost? Not guaranteed, how much? That's the economic decision that a financial advisor can help the decision makers with. Whether that happened, I don't know. I can tell you that when I get to 2003 DENF, that's precisely the analysis we did find from the financial advisors to the county. And in fact, I was surprised that at the volume of analysis relating to how much that guarantee was worth to the facility, maybe overdone, and maybe some other things could have used some attention. But that analysis has not been found with respect to any of the city guarantees. And I can conjecture, but instead I think I'll just point out in the audit, we found it curious that the guarantee fees did not relate to the size of the bond issue, because if you're looking at this from an insurance standpoint, I'm taking credit risk. How big is the credit risk? That has an impact on the size of the guarantee fee. The guarantee fee, through serendipity or something else, matched the structural deficit of the city. So it would get set on occasion to fill a general fund budget gap, a structural deficit, instead of how much money is it going to save? What's it worth? Is it worth doing it this way?
Right. And have you ever seen guarantee fees anywhere else in the Commonwealth?
Only in 23 years in one other municipality, and it was used for general fund budget reasons, and it's legal, and that's what I was told when I came across that the first time. I said, it may be legal, but why would you do it? So on this facility, and I used to know this in my head, but I don't now, if you add up the county guarantee fee, which was significant, and all the city guarantee fees, you probably get to another $7 million of debt that provided value or not, but it's on a facility that's not generating enough to pay its operation and its debt service, so why do you load up more debt on it?
Right. Well, maybe we should let you finish up the rest of that, and if you can leave some time, I think we all have additional questions, but we don't want to jump ahead.
Yes, I'm just getting into the audit now. But it's really, this is the core of it. So, okay, I better speed up. So, when 2003 comes, the city is faced with some choices. After the 2003 bond issue, there's now $104 million of debt, which today we would take in a heartbeat, right? We'd love to only have $104 million of debt to resolve, but we've got $340. So another stopping point, what do? You pack it in, you say, this was a loser. How are we going to pay the $104 million? One interview, they were looking at that. General obligation bonds, stranded debt, big mistake. Let's try to get it behind us as soon as we can. Or they could try to fix it, and it was too expensive to fix. There wasn't going to be a fix that they could find. They could find a fix that would be able to cover itself, but not cover itself and the stranded debt. So they found a unique and rather inexpensive option in some technology that had been used in smaller facilities and became enamored with it. And that was the Barlow retrofit. The Barlow retrofit was an idea that was close to just shutting the other thing down and building a new one, but it used parts of the guts. That's about as technical as I can get with the engineering. So they decided to go that way, and that's a whole trail that wasn't my part of this, but I would recommend people look at, which is bidding process, analysis, independence of how this came to be. But let's get back to, as I said, I could end and just go that way, but I don't want to do that. Self-liquidating debt, that's what I'm still on the first part. Is the $104 million of stranded debt still self-liquidating? If it's not, can I issue the big 2003 ABC transaction and still be under my debt limit? Okay, so here's what's going on at the time. This is the turning point of the whole project. Everyone knew the project wasn't working out. There's no way the city was going to be able to foot this bill at this time. The bond insurer said that, let me back up, I'm sorry. Let me get back to page 20 and 21. I want to give a little bit of context because I always jump right into the financing, and I don't think that's great. Let me give context to what's going on, because the county's going to come out of the blue now if I don't do this, and it's important to understand. So let's go to pages 20 and 21 of the report. Okay. January 2000, Dauphin County Commissioners create a task force. It's comprised of County Commissioner Payne, Mayor Reed, and Mr. Giorgione. Task force recommends the county create a city-county intergovernmental solid waste management office to carry out jointly the county's responsibilities for solid waste management. Spring of 2003, the county decides to seek waste combustion capacity. No more landfill, we want to burn it and turn it into electricity. After being urged by county municipalities to address rising landfill costs. So we're in a day here where landfill costs are going up. The municipalities are telling the county, get us out of this, and they're thinking maybe an incinerator retrofit will do the trick. September 23rd, 2003, the county looks at Chester, PA, an incinerator that's about 10 miles from where I live, and the retrofit. and designates that all county waste will go to the city of Harrisburg's resource recovery facility. Here's the problem. To be operational, this incinerator needed a major overhaul. The EPA's requirements under the Clean Air Act limited the volume of materials that could be processed, and the RF, it was just not going to be able to meet the future EPA clean air mandates. So now you've got the county and the city aligned here, that this is going to be, we're going to build. The insurer, that's where I was, says, well, we're not insuring the city's guarantee anymore. They've got more debt than they could ever repay. We've got more exposure to them than we want. And we have no idea whether this incinerator idea is a good idea or a bad idea, and whether it's self-liquidating or not, that's state law. We don't care about that. Only way we're going to insure this thing is if the county provides its geo guarantee. That's when, PFM gets engaged because the city wants to do a guarantee fee, and so the county wants to do a guarantee fee, and PFM is looking at the plan of finance, and this all comes together. Here's the choice that they had at the time. One, call the $104 million of stranded debt what it is, $104 million of stranded debt, and get rid of it off of the books. Unfortunately, had they done that, it's highly questionable that the city would have been able to guarantee the 2003 A, B, and Cs. And if they weren't able to guarantee the 2003 A, B, and Cs and that wasn't done, then the retrofit wouldn't have a city guarantee on it either. The only way it could be done would be with, well, there's a lot of ways it could be done, but a county guarantee with the insurer, could have done the trick. So it was, if and we did an analysis in the report, and I'm running out of time, so I'm not going to go through it, but it really shows you how the debt limits work. It shows you that if the 98s are no longer self-liquidating, then there wasn't enough capacity left to pay for the 2003 As. If the 2003 As weren't self-liquidating, there wasn't going to be enough capacity, and we have a chart showing that for the 2003 D and F. So it became one of those situations where if I had to conjecture, everybody's looking at this thing thinking, well, it might not cover $229 million of debt service, but all it has to do is cover $1 more than $125 million, and it's a good economic decision because then I don't have to write off all that debt. It might not be self-liquidating, but I'm better off having something that generates some cash flow towards it rather than, shutting it down. So choices: stop, go, but do not file a clean 8010B on the stranded debt, or double down. And they doubled down. They issued a report, and this gets back to your question, Senator Blake, that included, interestingly, Barlow, the engineer, designer, contractor, did all of the estimates of the operating expenses and revenues and projections, and the underwriter did the projections of the bonds, and they filed the report. It actually got kicked out the first time because Barlow only gave DCED the first 5 years of operations, and she said, if you want this to be self-liquidating for all 30 years, you give me 30 years of projections. And they went back and they just rolled the projections out, and that transaction occurred. I want to turn to page 52 of the forensic investigation. This is a good sum up of the team's concerns, so I want to point it out. And we're going to, again, we're looking at self-liquidating debt. Was it or wasn't it? The RRF experienced significant changes in circumstances from 1998 to 2003. Remember, this certificate that we're talking about says change of circumstances, no change of circumstances. If change of circumstances, decrease. If no change, keep. In 2000, the facility was derated to address EPA clean air requirements. substantially reducing its throughput and revenue stream. That's its tipping. The authority had to pay for operations and debt service, and I'm going to insert here because it was actually longer, 1996, again in 1997, in 1998, in 2000, in 2002, and in 2003, meaning that the facility was not paying for its outstanding debt during those years and had borrowed more expensive debt to pay off prior debt. So it added debt and it added expense. The projects that had been funded were not generating revenue sufficient to pay the debt service on the RRF. The original facility that the authority had purchased in '93 and improved through the '90s, in large part, didn't exist anymore at this time. So it was really difficult for us to understand how the existing debt could continue to be considered self-liquidating in '98, in 2000, in 2002, and in 2003, and how a clean 8110B certificate could have been filed. Nonetheless, the city filed a clean 8110B certification relating to all of those bonds. I'm going to try to speed up a little bit. The other interesting fact that we put in the forensic investigation is that right before this retrofit, 55% of the debt load was not acquisition or capital, meaning working capital, capitalized interest, 55% of it. So you think, how do you have $340 million of obligations and the facility's not worth that much? It's because of the paying your rent on the credit card time and time again, and guarantee fees and restructurings that added debt and increased debt service, and nothing productive happening down at the facility level that could help the authority generate more revenues. A lot happened between 2003 and 2006, and I'm looking at the clock, and I'm just going to tell you that you've got issues that you saw in the court with CIT. You've got a bevy of swaps that are now starting to try to generate cash because the real working capital that was proper for the 2003 DE&F retrofit, the real capitalized interest for those 2003 DE&F bonds was running out, and the facility wasn't operating at all. So there was all this money set aside for 3 years so that it could be built, and then when it opened, it would cash flow, and it wasn't even close. And Barlow just completely bonked. Ran out of money, all kinds of cockamamie schemes to keep it afloat. By 2006, so fast forward December of 2006, the authority terminates Barlow. Not going to happen. Brings in Covanta, who is the current operator. They've exhausted all means. I mean, they've hit 8 swaps already. They've done the CIT transaction that a lot of people said they didn't even know happened, and it was a license or it was a borrowing or whatever it turned out to be. The county's not going to put any more money in, and the city doesn't have the capacity to put anything in. And I think they kind of realize that they're in a lot of trouble, and people that were here that you talked to could tell you what it was like. But it seemed from the paperwork that it was pretty frenetic. It was crisis. So we're in crisis now. What are we going to do? Now we're up to $229 million of bonds. We've got CIT. We've got swaps. And if you don't walk away at 80 or 100, it's real hard to walk away at that level, $249, $250 million. So do you walk away, stranded debt, call them the guarantee? The thought was from interviews that you couldn't just sell it at a fire sale, not open, because you would take a bath. So put aside the law for a second, I get that. I get that if we could just put a little bit more money in and get it open, then we can sell it and we could cut our losses. I get that. Problem is that I think that from a contractual standpoint and from a statutory standpoint, there were some hurdles that needed to be attended to. And the determination was made in 2007 to finish this incinerator, get it open, and the price tag was estimated to be up to $25.5 million, and Covanta was going to operate after they engineered and constructed. So the city guaranteed its first 07 piece, and now we're back again to new money, construction contract, real good costs. City guaranteed it, the county did not. That borrowing could not have been guaranteed by the city under our analysis if the 1998s and the 2003s weren't self-liquidating. If none of it was self-liquidating, the city would have, when it went into DCED, been $140 million in deficit of borrowing capacity. I don't think none of it was serviceable. I think there is a portion of it that would have been serviceable once it opened up. But I don't know how much. But I'm just saying that when you talk about how did we get this far over, if none of it was being serviced at all, or would be serviced with the Covanta project, the city would have at that time in '07 been 157 million under. So we did some analysis to try to figure out, well, how much of it would have needed to be self-liquidating so that the city could have done what it did in '07. And it's just speculative, right? Because what we did was we searched everywhere for that analysis. Because if I was there and I saw this, and we had this discussion, hindsight's 20/20, so it's easy for me to say this, but you know, I expect Senator Eichelberger, I'm going to steal your question because this would be the next thing that we would, you know, look at in what we were talking about is, well, it can't all be self-liquidating because we haven't paid debt service since 1993. So how much would it need to be self-liquidating for us to be able to borrow what we need to borrow? And you would do that analysis, and the DCED proceedings would go in and say, we're going to reduce the amount that's self-liquidating by 40%. And lo and behold, we have just enough borrowing capacity left to do the Covanta loan, and the next one I'm going to talk about, the working capital loan. Wasn't done. We reviewed 17 sets of projections from advisors, and not a single one showed that all of the prior debt could be covered. And the 8110B certificate, not for the 07s, because they finally said, well, this stuff isn't self-liquidating. It wasn't sold as self-liquidating. But remember, the 8110B relates back to prior certifications. Are my 03 DE and F still fully self-liquidating? Yep. 03 A, B, and C still fully self-liquidating? Yep. Are my 1998s? Yes, indeed. So that filing, after all that we've talked about, and a lot more that's in the forensic investigation that we haven't talked about, still was a clean 8110B from the city and the county. Because the county guarantee related to the 2003 DE and Fs. And the county didn't need the debt capacity, by the way. The county could have said the whole thing is not self-liquidating, and they still would have had plenty of debt capacity. So the last thing that I want to talk about is the 2007 working capital financing. There's a lot of treatment of this in the report. There was a crisis atmosphere. There were new financial advisors brought in. There were, people who had been in the inner circle for a long time getting kicked out. There's all kinds of things going on with the authority board, appointments by council, appointments by the mayor. It's not a good situation, and people are trying to figure out if we fund this Covanta loan, it's still going to take a year or 18 months to get the thing operating. Who's going to pay for the working capital? Who's going to pay for the debt service on the old bonds? And so this is a $30 million working capital borrowing that raises a lot of questions in our mind. Let me get to a page so I can let you know where I am. We get back to the fact that debt service needs to be paid, there's guarantees, and the city actually pays on its guarantee in 2007. I think this was the first time. There may have been another time that they temporarily paid and got themselves reimbursed, but they paid on their guarantee, and we were, there were really no more tricks in the bag. And so the county needed to start advancing money for the first time in 2007. And a lot of professionals were involved, and a lot of fees were accumulating. So this borrowing gets to really what are the proper purposes for use. So we already talked about how could it have happened under the debt limit. So let's talk about a little bit, and as the forensic investigation does, what was this money spent on? And does that raise any questions? So I'm going to turn to page 115, sorry. So this is the exclamation point for it's really self-liquidating debt still, 98 and 2003s. So there's all these adverse changes. Barlow's performance wasn't happening. No payment in performance bond. So inadequate security for replacement. It would have been great if there was, and Covanta came in and the bond company paid the 25.5. That would be 25.5 less. The authority had incurred significant additional obligations through the CIT arrangement, through swaps. Authority was generating revenues to pay for, they had operating costs and construction cost overruns, so that's got to be paid for. So the price of the project's going up. It's just really hard to believe that people sat around and said, the old debt's still self-liquidating, we won't make this debt self-liquidating. By the way, we found an email that actually went to the financial advisor that said, where's the self-liquidating debt report to make the 2007 borrowing self-liquidating? And he was like, are you kidding me? There's no way. But really, that wasn't the question, because there was no way, because that was offered to the market not on the basis of any security on the facility. That basically said, we're either going to sell, we're going to have a revolutionary change and restructuring, or look to the county and the city. And at this point, if anybody thought that the city could cover this debt, they were out of their minds. So, that was sold in an unrated private placement to high net worth Wall Street funds at a very high interest rate with very high degree of risk. So everybody knew, and this is an important distinction because I talk to people about this a lot, the 2007 bonds were not prepared and presented as self-liquidating themselves. It's that, remember, the occasion for downgrading other self-liquidating debt is when you go into approved debt. And it was the absence of the 8110B downgrade by the city and the county on that occasion with respect to 98 2003s that we found problematic. All right, so the money that was spent on the 2007s, in large part, and this gets back to the documents and the flows. One reading of the documents is that if you have to pay under a guarantee, you're subordinate to everything that came before you or to everything that is senior to you. And clearly the 1998 bonds were the senior secured position. So if the city paid under its guarantee, which it did, then one reading of the documents is that you don't get repaid, city, until the 1998 bonds are paid off. It's a reimbursement obligation, but you don't jump the line. You don't get ahead of bondholders. Same with the county. County had a guarantee. When do they get repaid? Well, they got repaid out of this $30 million working capital borrowing. The $30 million working capital borrowing was troublesome for several reasons. One, really was capitalized interest on the 98s and the 2003s. If we go back to the definition of capitalized interest, the 98s really relate to the 1993 acquisition. Okay, that project was capitalized back in the 1990s. How do you capitalize interest in 2007 when the law says that you can capitalize interest during construction and if necessary for 1 year thereafter? With respect to the 98s and the 2003s, they were all related to the original facility. So there was this mental leap of faith that occurred by everybody, that this was one long project. I'd agree that it's one long disaster, but I don't know that I'd agree that it's one long project. That the guarantees probably should have paid for the 98s and the 2003s. And capitalized interest makes sense on the $25 million Covanta loan. Problem is that they wanted everything back, and they didn't create the Covanta obligation ultimately as an interest-bearing obligation. I'm sorry, the working capital loan, the 2007 to 2010 was what we call a capital appreciation bond. No current interest. It matures in a bullet, there's nothing to pay. So I could imagine that you could put together Covanta and the working capital loan in 2007 and say, that's one project. And you could say, and I'm going to capitalize interest on the Covanta project, that $25 million. That makes sense. Can you capitalize interest on the 2003s? That was 4 years earlier. The argument we got was, well, that project never opened, and so Covanta project is the completion of the Barlow retrofit. That's how the argument goes. If Covanta is the completion of the Barlow retrofit, then it's construction plus one. We're not construction plus one, so 2003 is, that's the argument. I think it's the strongest of the three. 98s and 2003s, how did that become part of the Barlow retrofit? It was prior in time and related to the original facility, not the retrofit. That was our trouble with capitalized interest. It makes sense economically, because if they didn't do that, then guess who would have paid? The county and the city, under the guarantees. And if they were to follow our reading of the documents, they wouldn't have gotten that money back for a long time, certainly not today. They would have gotten it back after the 1998s were repaid. But it was expedient to do it this way, and so it's done this way. So here's $30 million of debt that's going to pay professionals. It's going to capitalize interest on, Covanta loan, on Barlow retrofit, and on 1993 project working capital. Again, loading up debt on a facility that really didn't have a chance once they decided to double down. May have had a chance if the $104 million was stranded and they took that out of the equation. They had a payment and performance bond, and Barlow bonked, and they got it completed readily and didn't do some of the other things that ended up costing. May have had a chance, not to be completely self-liquidating, but it would have been a close call. But this didn't have a chance when they doubled down, and then to add another $55 million of debt, 30 of which is called the working capital loan. So you remember I started, and I'm going to finish with this idea of working capital. It's something that we want to look at. Capitalized interest in working capital. What is it? What should it relate to? How much should there be? It's a bad sign, but necessary sometimes. And a lot of times, you just need a little working capital to get through to the next year, and you could right the ship. But here's a situation where the course of conduct was to keep borrowing to pay working capital and debt service and loading it up. And that answers the question, how do we have $340 million of debt on this facility that would otherwise be fine? Thank you.
How about we unveil a chart that we have here this morning and have you walk us through that chart very quickly? Would that be, so, you want to do that? Why don't you face that, Lee, so that Mr. Goldfield can see it and the audience can see it. We all have we have a copy of that in our packets up here.
Senator, do you want to say anything about it, or would you like me to introduce it?
If you don't mind, just take us through it quickly.
One of the common themes of today was that there really never was enough revenue available for debt service and operating shortfalls. And so we put together this illustration, and you could see that there's not very much above that zero line, and anything that is above that zero line is in blue, and that's the revenue available to pay debt service. The red is the overall shortfall. So I want to just introduce the methodology here, because I'm not an accountant. And lawyers playing with numbers is dangerous sometimes. But I want to tell everyone what this is derived from, because you could do it differently, but I don't think the picture would be dramatically different. We took the audited numbers from 1998 through 2009 regarding the operating expenses and operating revenues of the Resource Recovery Facility. So this is derived right from the audit. We didn't take non-operating revenues. They're not a lot. We didn't take non-cash expenses like depreciation. This is a cash look. This is, here's how much cash it takes us to operate. Here's how much cash we got. What's the difference? Okay? The city has not yet released its 2010 audit, and we hope that it's going to happen in this year, and it's getting close. But I didn't have audited information for 2010 through 2012. So the best thing I could find was the budgets of the Harrisburg Authority. So for 2010 through 2012 in this chart, we're looking at the budgeted numbers for operating revenues and operating expenses. And then for that period, we also calculated debt service, because remember, there's a lot of variable rate debt, a whole nother conversation. And there was a lot of synthetic variable rate debt, meaning that swaps turned fixed rate debt into variable rate debt. And so those go up and down and up and down, and we did some calculations of what it should have been. And then in 2010, when the 2010 note matured and the county took it over, the county started paying under its guarantees. The bond insurers started paying under the bond insurance policy because the city couldn't. And they started charging interest on interest and penalties, and it just, adds up, and that's how you get, up where we are. I didn't add all of that. What I took was, what if this train wreck didn't occur? What was the debt service supposed to be? It would be worse if we added, all of the interest on interest. But you'll see this huge thing in 2010. That is the bullet maturity of the 2007 note that the city guaranteed. So that's the big one there. So the other, let me just see if there are any other assumptions. Right, okay. So let me just explain the color code here. The orange is the annual debt service. Notice how the orange gets bigger, bigger, and bigger as you go. That's consistent with what we were talking about. The blue is the revenue available to pay debt service. You'll see that it is negative in the majority of years. Okay? So what that's saying is it may not have done what we would need it to do if the city paid the debt service that was owed under its guarantee, because there was negative revenue available to pay debt service. There wasn't enough to pay for operations, hence all the working capital borrowings. The red is the shortfall, and you could see that there's not a year between 1998 and 2012 that we don't have a shortfall. And, that causes us a lot of concern about how during that entire period could each and every one of these bond issues other than the 07 be self-liquidating.
Thank you very, very much. How about we take some time for questions here? And again, if we can limit ourselves to one or two, and we'll just rotate. You want to go first, John?
Thank you, Mr. Chairman. And again, Attorney Goodfield, I'm deeply grateful, notwithstanding your recent statement about lawyers and numbers. One of the issues that you brought up and have consistently echoed in your remarks is the issue of this working capital, capitalized interest. I understand the concept of it. Is there a means by which we could restrict borrowing that is so predominated by, you said up to 55% in one of the deals? Is there a way that we could restrict borrowing in a manner that would prevent what you've described as a cascading borrowing for working capital on the percentage that we could permit?
Yeah, I don't know if I would go with a percentage. I think that the language that the legislature has in the statute makes sense. It's initial, reasonable working capital, and capitalized interest during construction for a year. What I am seeing more of is these restructurings and acquisitions to fill structural deficits. For instance, putting aside these restructurings, you're going to find more and more, and I've seen a handful of municipalities selling off an asset that it may need or it may not need for a price that doesn't have that much to do with what it's worth, but has to do with what it needs to get through the budget year. And so, as an example, a building that the city doesn't need anymore gets sold to an authority for $15 million. Now, bond counsel, a lot of people need to sign off on this, by the way. So you do have professionals out there who are, the police for this. Once the acquisition occurs, 100% of the bond proceeds go to the city, and the city puts it in its general fund. That's a working capital financing. But under the Debt Act, it's an acquisition financing. So there are different ways of doing acquisitions that aren't intended necessarily to generate just working capital. There are different ways of doing restructurings that make sense. So it would be throwing the baby out with the bathwater to say, under no circumstances can you do a debt restructuring. I think we may all want to focus, and there's plenty of people that do this across the state that could be helpful as well. And I know Bernadette Barattini is going to be here, and she's got a wealth of experience. I think where we might want to focus is on what excessive working capital and restructuring financing should say vis-a-vis self-liquidating debt. That I can make an argument that the language in the statute's pretty clear, that it's rates and revenues of ultimate users are the sole repayment. So, but this is kind of a backdoor. I'm reducing my expenses this way so that the rates, revenues of the ultimate users are what's paying debt service. But it wouldn't be that way if I weren't doing these expensive scoop and toss. So it's hard for me to segregate the working capital, cap-I, and the self-liquidating debt concepts. But the language is pretty clear. How it gets enforced is a question. What it means, this is not uncommon across the country. there's not a wealth of judicial interpretation of what those words mean. The DCED has a very small department that looks at these, and they have, a very, defined role in looking at it. There are opinions that if somebody protests in a timely manner, goes up to an adjudicatory hearing, and those opinions are released. And so there's a little bit of interpretation, but not very much. But
Thank you.
the statute itself, makes sense the way it is.
Right, and I think that your point is well taken. I think the chairman would probably agree with me on this, that we need to look further at either tightening that up in terms of its interpretation, bringing the experts in to help us articulate something that would be a little bit more in protection of the taxpayer's interest. I don't want to take too much time, and I know we're going over already. I had two other things. We didn't get to swaps. But there has been an awful lot there was significant discussion about that in your forensic audit. The Act of 2003 by the General Assembly that allowed local government units to use these interest rate management agreements. I think at the time, I wasn't in the legislature at the time, but my guess is that they didn't exist, so we had a lot to consider how they would come into play in the market and how it would affect our local government units. So I guess what I'm asking you now, after, again, based upon your experience and taking a look at this, and Auditor General Wagner has gone on the record that perhaps he thinks we should revisit that act in 2003 that allowed them. What opinion could you render, or observation could you render about whether or not these transactions, let me just put it in this context. I'm not sure that the local government officials who are making the decisions and who have an obligation to assess risk to some extent to the taxpayers are as financially literate as the professionals who are making the assessment. In this particular circumstance, these transactions did not reduce the cost in the financing. They increased the cost of the financing. $2 million to protect against a 12% interest rate. So I'm asking you whether or not you think, from a professional, in your professional observation, should we revisit whether or not these even should be permitted in these kinds of transactions?
I was around when Act 23 was enacted and actually participated a little bit in trying to help draft the protections, and was asked just to volunteer for DCED and go around the Commonwealth and try to explain what these are, what the risks are, what the benefits could be, how to use them properly, how not to. And it was a 50-page PowerPoint, and there were very few people that were remaining in the room by the end of my presentation. I've done a lot of interest rate swaps. Prague has some very large, sophisticated clients that have a lot of interest rate swaps, and used appropriately, they are a good interest rate management tool. I'm talking about New York City, New York State, Los Angeles, the state of California, where you've got a department that manages debt, where you have real swap policies that have been thought through. The bases that are supposed to be touched here under Act 23 are to have an interest rate management plan, but we saw in this process that somebody prepared it, threw it on the table at the meeting. One paragraph in the resolution approved it, and no public official, I would bet, read any of it. And then they did more swaps that violated their own interest rate management plan. So just having the piece of paper doesn't do the trick. I think that larger municipalities can use these well. Very sophisticated municipalities with independent, very sophisticated, trusted advisors can use these well. But since the market dislocation in 2008, they're not working very well, and I don't see anyone even wanting to enter into them. It used to be, the whole idea of a swap is that it'll taste just like chicken, right? This will be just like a fixed rate debt, and it's not like that anymore. There's so much market dislocation and so much volatility that, in today's market, I can't imagine a Pennsylvania municipality that I would recommend get into one, and I could tell you that I've spent more time in the last 5 years unwinding them and getting people back into traditional fixed rate bond issues at cost, because it's just not worth that risk. And, I don't want to make a blanket statement that no municipalities, can handle this. But this is, it's like a loaded gun, it could protect you, but you got to be really careful and really trustworthy, and it could go off. And when it does, it could be really expensive.
Thank you. Thank you, Mr. Chairman.
Senator Fulmer.
My first question, sir, and I appreciate you being here today and going through this. With all the apparent alarms going off and red flags being raised about the ever-increasing debt load on Harrisburg Incinerator and its inability to repay, who do you think had the responsibility to say, we shouldn't be doing this?
I think that there's not a person in the report that didn't have an opportunity to do what I've done one time in my professional career, to go to a client and say, this is going to be horrible for you, but I'm telling you not to do it. It's not the thing to do. I think you're going to talk to some people who are elected officials, who are appointed members, who are professionals, and I would leave it to you to decide, relatively speaking. I don't know that it matters, relatively speaking, who. What matters is that no one did.
Okay. My next, thank you very much for that question, and because of time, I'm going to keep pushing with my questions here. This refers to the 2007 loan, the $30 million, the $29,994,808.85 in 2007, all but $1,810,600.33, or seemed to have been paid in fees, the $28,184,208.54. Now, some of this Covenant especially seems to have gone to that project, but what was the $28 million spent for?
Yeah, just give me 1 second.
I know I asked that quickly because
and avoid it having to pay anything for the next 3 years. Reimburse City of Harrisburg for everything it advanced and covering it for the next couple of years. Pay debt service. Now, remember what you just said. Let's see, it was $1.8 million, was it, of new money?
Yeah, it was.
So what's the capitalized interest on $1.8 million if that's the project, right?
Okay.
It's in the dollars, okay? The next category is capitalized interest. Is capitalized interest on that? Is capitalized interest on the retrofit? Is capitalized interest on the 03s? Is capitalized interest on the 98s? We don't want to have to pay anything for the next 3 years, even though we have guarantees. So let's borrow and pay that debt service. And then it's the professionals. That's the last category. And you can see we spelled out exactly, what each professional got paid.
Okay, thank you very much. And my last question real quick would be, would you briefly comment on the 2003, quote, City Council Fund on page 48 of the forensic audit?
I can't because that wasn't part of my responsibility. I only know what I've read in the report. I would suggest that we can go back to the people who prepared that portion of the report and submit a response or comment at a later date if that would be satisfactory.
Well, I guess it would have to be. So, thank you very much.
Or there will be other people that you could ask that question that maybe could answer it.
I'll keep that open. Thank you.
How about a follow-up on that? Have you ever seen a special projects fund in any other case?
No.
Do you have any idea in total, which I think I've seen this figure, but I just don't remember, I don't know if you know off the top of your head, how much through the years went to professionals through all the borrowings, all the swaps?
I'm going to say that we did the best that we could, and we took sources that were publicly available and made available to us, and it's not complete because we didn't get everything that we would need to make it complete. But I'm going to point to an exhibit that is Exhibit H, as in Harry, that takes from 2003 only, okay, to 2010 only, and shows by professionals, by firms, etc. It gets tricky, and this is the swap question, right? So in a swap transaction, not everything you pay to the swap counterparty is fee. There are aspects of it that are, volatility risk that you have to pay for. There's fee. If you're off market, you may have to pay for that, and vice versa. So when you see numbers, you can't go with a broad brush and say they made $2 million on those caps, or how much they made on the, and what's hidden in swaps is that if it's off market, meaning that it's not priced right on the market that day, they can get paid over time through a couple basis points in interest rate. And on a $92 million swap over 30 years, that's a huge amount, and that doesn't get reported anywhere. That's calculated. So what you see here is, at best, a really strong effort at taking everything that we got from everyone that volunteered, taking everything we got from the Harrisburg Authority, and taking all of the transcripts of all of these bond issues, poring over them and compiling them in this exhibit.
Thank you. How about one last question for me is, could you walk us through and explain how this works, where it's stated and what document we follow, and how things should work as far as payments? So when we see all this refinancing that's happening over the years, in a recent example you just discussed where the county was made whole, the city was made whole, and so on, the order of how people should be paid, the protections involved in the indentures and so on, how just typically how it works, not necessarily specifically in this case.
Yeah, typically is better than this, because this is, as Senator Fulmer said, I'd say that the Harrisburg Parking Authority and this indenture structure are two of the more complicated ones I've had the pleasure of reviewing. We tried to do this, Senator, and it's really difficult to follow. I'm saying, and I wrote most of it, because it is, there are so many buckets and so many priorities. But I'm going to answer your question, but I'm going to point to page 123 of the audit that says priority of bonds. Because the first place that I would look as a professional is, there's all these bond deals. Are they on parity, which means they're all equally treated? Or I think lawyers like to use Latin words like pari passu. Or are there senior and subordinated bonds? And not within necessarily the purview of the committee, but certainly within the purview of the report, was, in my experience, you have a strong additional bonds test that is another gatekeeper to prevent the continual issuance of debt that you could never repay. And in my experience, either the professionals put that in for a revenue-producing facility. For instance, you've got to be able to look back, and that's what it usually is. It's usually a look back and a look forward. 1 year or 2 years, and meet a 1.2 times, a 1.3 times coverage ratio, meaning not only did I pay my operations and my debt service, but I had 30% more than I even needed. So even if I have a little problem next year, the amount that it goes down by will not disable me from paying my debt. So the rate covenant was 1 times. Why? The only answer could be that the bonds were being underwritten and the bonds were being insured on the basis of the geo guarantees, because you don't do that in a revenue-producing facility. You always know that expenses can go up and revenues can go down, and things are volatile, and you need a coverage. So you need coverage so that your rates are set to cover every year, and you can't incur more debt unless you're paying for your existing debt. That's basic contractual security, structure, not legislative, not statutory, that's basic. The way that the trust indentures get convoluted is that they do say that if you're not covering at least 1 times, meaning I paid my debt service this year. You can't issue more debt. And how could you issue more debt if you can't even pay what the debt that you have? But you needed some certifications, some engineering certifications to give comfort to the trustee. And apparently, they didn't feel that they could get them. And so they issued subordinate bonds, meaning not on a parity with the 98s. So the 98s were senior. The 2003s were issued knowing that they had to market the 2003 D, E, and Fs. And they were made not even subject to the pledge of the revenues, and that's how they got out of the additional bonds test. And they did that again in 2003D, and they did that again in 2007. And so you have these layers of subordinate debt, and it's a workaround contractually that works. Is it financially prudent? That's a different question. The subordinate debt additional bonds test that I would typically see in a deal like this is less coverage than the senior debt. If you're going to issue debt on a parity, I want a 1.3 times coverage. Subordinate debt, 110. I want at least 10% more than I've needed to do this. The subordinate debt covenant in these contracts was non-existent. As long as it wasn't on a parity, you could do it. It didn't matter. And that's how they rolled this out through the 2000s. Another gatekeeper that, professionals, contract structure, underwriters, advisors, issuers that, that know these kinds of things could have incorporated, not in the deal.
Senator Fulmer.
And this will be real quick. This is a little bit of a hard question, and that's for you to answer, but what, if anything, should we be doing to prevent such problems in the future? Do we need to change any laws as a legislative body? Do we need more openness, transparency, and accountability? Do we need to add criminal penalties to existing laws? What do we need to do so this doesn't ever happen again?
I'd like to suggest that what you're doing is so important to us because it'll help us figure out an answer to that question.
Okay.
There are many people who we would love to have talked to and found out, really what were the problems. You can't legislate good financial taste. You can't, require professionals to do certain things, but so I don't know if this is going to come down to a legislative fix until we hear really from everyone else and get the rest of the documents. We have pockets, so my thoughts now I think are premature, but I would welcome a call from you after this process ends with the exact same question.
Okay, will do. Thank you very much.
Thank you.
And one quick follow-up from Senator Blake.
It's a real follow-on from that question, and I think you've spoken to the issue that your forensic audit, you didn't have the ability to compel compliance, and whether or not we should, as a legislative body, consider asking the Auditor General to look into it in a deeper fashion, because he would. Is that a worthwhile request that we should make at the Auditor General's office?
Okay. Pardon me, may I ask you to repeat that?
I'm just saying that you didn't have the ability to compel compliance. You asked if you got it, and you used it. Should we consider as a committee reaching out to the Auditor General's office to take a deeper look where he may have the ability to compel?
No one's ever asked me a question like that before, and I believe, and the people that I've worked with believe, that it would be helpful to get the complete picture to avoid a reoccurrence. And we're trying to also look forward and say, doubtful that anything like this will ever reoccur, but are there lessons that could be, legislated? And I just don't know. There's the tension between the kind of palliative effect of getting the entire story out. And I don't know if we'll ever get the entire story out, because there's a lot of people that have representation now in civil litigation, and I think people are going to be very circumspect about what they share in light of where everything is right now. So the question is, is that, if it didn't have a cost and I knew that it could happen, and it could happen without an extraordinary amount of effort, there's a lot of people that would like to see that. It would have a cost, and the longer that this, is discussed, and there's no, conclusion to it, the more difficult it is for people to move forward.
Understood. I understand, and I appreciate your care in that response. The issue is cost benefit. I mean, there is already quite substantial learning in the work that's been done here. And I think things that we could act on in the learning that we've had this morning and in your testimony. So the question is whether or not, we could, I think, have sufficient information to make the appropriate changes. And that's the issue.
Yeah. And if I may, I think the forensic investigation touches on a lot of issues. And as I said, we went down a lot of rabbit holes, and I'm suggesting that other people might, if there's this, comprehensive review of everything. It might make sense to pick off a few of the issues that were raised but couldn't come to conclusion that are most troubling, and focus on a priority list as opposed to trying to figure out everything that happened, because it's such a long period and there are so many different issues that have been raised.
Very good. Thank you, sir.
Okay, we're tremendously behind schedule here. Our first witness, that's not a good sign for us, but we knew this would be somebody we wanted to take some time with, so we greatly appreciate your time, Mr. Goldfield, and all the work that you've done. We've all read the report, and many of us have had discussions with you prior to this, so that we know the time that you've put into this and in your continuing effort. And Mr. Morris, thank you for being here today, and we appreciate that very much as well.